Anyone else here? Ms. Roberts, you're someone trying to get your attention, I believe. Maybe might be trying to get my attention.
No, I just can't.
All right, let me get these back.
What's our next stop? It's something March 14th.
So, Dawn, is this your first time in the hot seat here?
Second.
You're
It's been 2 weeks since we had jury trial.
All right.
There are 2 pro-ses.
Yeah?
Yes.
Okay, well, we'll go ahead. Are they here?
Yeah, Mr. Clark's here.
All right.
Not sure.
Let's go ahead and address, is Daniel Clark here?
Yes, sir.
Would you come on up to the podium, please, Mr. Clark? One moment, please. Okay, Mr. Clark.
Yes, sir.
The state alleges a couple. Okay, let's go ahead and turn the phone off.
Is there anyone else who didn't sign in?
A couple criminal traffic type charges. They allege that you were. Is there anyone else? We'll be taking up Mr. Farnham in due course here. Anyone? Any other?
I object. I object.
Shh.
I'm not gonna-
Hush now.
I'm just here specially visiting about the RONALD Trust, of which I'm beneficiary and not.
Anyone else? What's your name in the file? We're taking Dr. Williamson up now. Oh, Dr. Williamson, can you hear me? Dr. Williamson, can you hear me? Apparently not. Oh, Dr. Williamson, your microphone is muted. Could you unmute your mic?
But he's not responding either way. Oh, there he goes.
Could you press the microphone icon up by the red leave button up in the right-hand corner to unmute your mic?
Oh, okay.
Could someone there, could you unmute your mic, please? It looks like an old-fashioned microphone up there with a line through it. Could you unmute your mic? I cannot hear you.
You might be able to go in and undo it for him. I don't know.
What's
I
that?
don't have the power. I know you can go in and mute people. I don't know if you can.
I
unmute
cannot
them.
unmute people with this program.
Well, that's good. That makes me feel better about using Teams. You can't just.
Lisa, would you go ahead and send him a chat or an email to unmute his mic?
There he is.
There you are. Can you hear me?
Yeah, he just muted it again.
Dr. Williamson, can you hear me? No, it's muted again. You.
Judge, can you hear me?
Yes, I can hear you.
He might need to go into his settings on Teams to allow audio capability because it might be like a privacy thing. I had that issue as well when I got my computer, where I would unmute my mic but it wasn't working because in my settings it was disabled. So he might need to go into his settings either through Teams or through his actual computer settings to allow the audio capability in order for his mic to be unmuted.
Would you go ahead and send him a chat or on the Microsoft Teams and an email to that effect, please?
Well, if he can hear me right now, I might be able to talk him through it. Dr. Williamson, can you like give me a gesture, like a thumbs up if you can hear me?
Yeah.
Okay, I guess not. So I'll send him an email, Judge, and then
Wait, he
go
just
from there.
unmuted it a moment ago and then he remuted it.
I didn't see that,
It
but
was unmuted a moment ago. I believe it was.
I don't know if he can hear us though.
There's no indication that he can hear us.
Yeah, he's not responding.
I mean, it's possible his volume might be turned down on his computer. I mean, there's really no way for me to know what's going on his
Do you have a
side.
telephone number for him, Lisa?
Yeah, 1 second. I can give him a call if you'd like, and I can talk him through it.
Well, I'll just talk to him have him appear by video here and on the speakerphone. Can hear and we can hear him and see him contemporaneously. What's his number, if you have it?
It's 321-610-4703.
Dr. Williamson, pick up the phone. He can't see me.
I don't think he knows that we can see him.
Dr. Williamson, pick up the phone. Pick up the phone.
Is the other lady may be going to answer the phone?
Pick up your phone. I'm calling you. I'm calling you. I'm calling you. Lisa, would you indicate by chat that I'm calling him? He should answer the phone.
Yes, I'm doing it right now.
There was.
Can you hear me?
Yes, I can hear you, Dr. Williamson.
Yes,
Can
sir.
you hear me?
Yes, sir.
Very well. We've made contact. We had some technical glitches there, but I'm pleased to be able to talk to you.
Thank you, Your Honor.
Can you see me as well?
Yes, sir.
All right. I'd like to go ahead and focus the. I have some questions that I wanted to ask you, but I wanted to focus the camera back to the defendant and counsel. Give me
Okay.
a moment, please.
Okay.
All right. I'm not sure you can see everyone. Give me a moment. I'll move the camera. I'll move the focus on the camera.
Okay.
Up, wrong way. There we go. That's about as far as I can go, given the limits of this.
I have a general sense.
All right, very well.
Okay.
First of all, we're on the record here, and we're in a competency hearing, and I wanted, there may be some subsequent appellate review of this matter, Dr. Williamson, so I'd like to go ahead and swear you in at this point. Do you swear or affirm that any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Now, counsel, I'd like to start the ball rolling, and then I'll give you an opportunity to ask questions. Dr. Williamson, could you first tell us a little bit about yourself, and putting this on the record, what your credentials and qualifications would be?
Yes, sir. So I am a clinical psychologist, Jeffrey Michael Williamson, and been in private practice since 1991 and in Florida since 1990. Well, I'm sorry. I've been in practice since 1991 and in Florida since 1992, going into private practice in 1996. I have a PhD from the University of Missouri, Columbia, Missouri, with specialization in child clinical psychology. I have testified in court over 2,500 times, and I'm currently in private practice in Melbourne, Florida.
Thank you, Doctor. Does either side object to the court eliciting opinions from Dr. Williamson in the field of psychology?
No, Your Honor.
No, Your Honor. Tell you my head stopped there for a minute. I thought Ed
Dr.
said-
Williamson, I had entered an order calling for an evaluation of Ronald Russell Farnham for competence to proceed, and you received a copy of that order. Is that correct?
Yes, sir. Yes, Your Honor.
Now, you have reviewed various documents purportedly authored by Mr. Farnham. Is that correct?
That is correct, Your Honor.
And his pursuant to an appointment, I understand, made by his counsel, he appeared at your office for the interview that was contemplated by that order. Is that correct?
That is correct, Your Honor.
Now, we have, both counsel and I
object.
have reviewed
Your Honor, I specially visited on that matter.
have reviewed
I object.
Hush
I
now.
object.
I've reviewed a document entitled Competency Evaluation of yours regarding this, and you authored such a document. Is that correct?
Yes, Your Honor.
Now, my impression of that document is that it involved impressions of Mr. Farnham, but it did not have the evaluation associated with each of the criteria for competence as would be typical and as would be called for by the order. Is that a fair description of it?
That is correct. Yes, Your Honor.
Why was that? Why?
That Mr. Farnham refused to answer any of the competency questions or
Object.
typical background information invoking his right to remain silent.
Now, you reached some impressions, however, notwithstanding that invocation. Is that correct?
That is correct, Your Honor.
Could you share those impressions with us?
Yes, Your Honor. It appears to me that Mr. Farnham is suffering from delusional disorder, primarily grandiose and persecutory type, and that typically is a diagnosis that is part of individuals that have psychotic processes. However, you can have delusional disorder without hallucinations or thought disorder, things of that nature. I would add that having reviewed, and at that point there was only an initial document filed, actually a written note, I believe, from his mother, but having read over the other documents, I would add some concerns about, possible thought disorder, and I say that simply because the legal texts that or responses that were made by Mr. Farnham are difficult to understand. It seems very similar to what we would call a word salad type of presentation when we're talking to someone who is suffering from a psychotic disorder, and they're basically not making sense. There's what we call loosening of associations and referential thinking, where they will go back to what they've said before, but really there's a lack of coherence, if you will, in their oral presentation. So in looking at the written documents, and certainly I'm not a legal expert, but looking up some of the words and things that were used by Mr. Farnham and the general presentation of the documents, it would look nonsensical, if you will. It's not clear to me what point he is making or what his defense is, even though he, is making the point that he's able to represent himself. So all I'm saying is that in addition to the delusion that I definitely saw, I do have some concerns now about a thought disorder.
Dr. Williamson, I wanted to ask you about the nature of his apparent delusions.
Yes, sir.
Oftentimes, we see people who have some unorthodox beliefs here in court, and they sometimes are part of what might be characterized as a sovereign citizen movement,
I object.
where they
He's a sovereign citizen.
where
I object.
they
I
are
object. I object.
where they're oftentimes seeking to frustrate law enforcement and obstruct the processes in court.
Yes, sir. I'm sorry.
Is that a fair characterization from your impressions of Mr. Farnham?
Certainly I can see that as an interpretation, and I am aware of this sovereign citizen concept or idea. Having evaluated individuals who have taken that approach, I would say there is a distinction with Mr. Farnham, and that distinction would be, while I do agree that there's an attempt to, in essence, say that the laws and judicial process, do not apply to him, the reasoning is substantially more illogical, it seems to me, than your typical individual who is making that sovereign citizen, if you will, defense. So what I'm saying here is that there seems to be a lot more disorganization and lack of clarity. And even though when you evaluate individuals with the sovereign citizen concept, they often have presuppositions, et cetera, that are, let's say, equally unusual or distorted. But we could say persecutory delusions might be there as well. I would distinguish Mr. Farnham's situation because of the lack of coherence, if you will, at least from what I've read, as to what really his argument is.
Dr. Williamson, there's an assessment tool used for the evaluation of delusions and delusion-like beliefs. It's called the Brown Assessment Belief Scale. Are you familiar with that?
I am familiar with it, sir, yes.
Is that something that would be useful in evaluating the delusions or delusion-like beliefs of Mr. Farnham?
Well, certainly would provide an empirical basis beyond just my observations, and certainly can be done. Again, my concern would be level of cooperation, and if using that, my own observations, I am aware of this instrument. I've not used it personally, so I don't know if it's a primarily observational measure or if it's a self-report measure. So I would have to look into that. If it's a self-report measure, then I don't think we're going to get any better information than we already have. If it's an observational measure, then it would give us a better, I think, empirical basis for my conclusion.
I was reading an article last night. It's entitled Integrating Non-Psychiatric Models of Delusion-Like Beliefs into Forensic Psychiatric Assessment. The author is Joseph M. Pierre from the Journal of American Academy of Psychiatry and the Law Online, June 2019.
Okay.
It states in part as follows. Assessing the pathological nature of beliefs is fraught with challenges. However, including the limited options in the Diagnostic and Statistical Manual of Mental Disorders, DSM,
Yes, sir.
for the characterization of delusion-like beliefs, DLBs, the expanded cultural sanctioning of fringe beliefs in the age of the internet, and the potentially conflicting agendas of clinical and forensic psychiatric evaluation. So my question is, if the assessment is so difficult, how can the court make this determination, or can the court make this determination with respect to competence where the defendant is not cooperating, where there's no, there has been no empirical assessment of his beliefs or delusion-like beliefs, or his delusions?
Well, I think we have, and if I understand you correctly, Your Honor, typically it is fairly apparent when individuals are delusional that, by the statements, et cetera, that they make or other correspondence, and clearly what I'm going off of in a major part is the, correspondence. You are able to identify some of the major parts of it. In application to, forensics, I think one of the questions that's being asked is this either malingered presentation or a just outright, attempt to obstruct the legal process. And that's where it becomes a little more difficult sometimes, is distinguishing between whether it is a legitimate presentation or, malingered in some fashion. Regardless, part of the problem that I had with this evaluation was in exercising his, right to remain silent and not responding to, my questions. All I can say is that the effort wasn't put forth, the ability to observe the defendant was minimal. So in and of itself, my primary response to that was looking at the documentation, et cetera, that it did appear to me that there is actual delusional content. But if further assessment along more empirical lines, like using an instrument like that, is beneficial, I'm certainly more than willing to assist the court with that.
That brings me to my next question. And let me preface this with a quote from Through the Looking Glass, a classic children's story by Lewis Carroll.
Yes, sir.
Which the quote begins with the words of Humpty Dumpty. When I use a word, Humpty Dumpty said in a rather scornful tone, it means just what I choose it to mean, neither more nor less. The question is, said Alice, whether you can make words mean so many different things. The question is, said Humpty Dumpty, which is to be master? That is all. Is this merely someone who is just using language in a way that makes him feel special and important and different from other people in a way that tends to frustrate the processes of law enforcement and the court system?
I object.
Or is this someone who has legitimate
I object.
mental
You're leading the
issues,
doctor.
issue,
It's a false statement. I object.
mental issues with
I
respect to?
object.
I'm just trying to get this out over his
Yes.
objections
Yes.
at this
Yes, sir.
point.
Yes, Your Honor.
So that this is a product of some legitimate, cognizable mental disorder. That's my question. Do you understand my question?
Well, yes, I do understand your question, and I would say that having reviewed some of the documents and so on, I would be inclined to say that I think this is a product of a true mental disorder, but I also would add that in scientific reasoning, particularly in behavioral sciences, a both-and hypothesis is generally most correct. So I certainly would proffer the idea that we have a both-and, that there is legitimate psychiatric issues going on, but that there also may be a deliberate intent to frustrate, if you will, the court process.
Now let me ask one further question, and I'll open it up to the attorneys. In the event that the court were to find Mr. Farnham to be incompetent to proceed, and the court directed him to some remedial measures designed to restore him to competence, would he understand the obligation to appear for those, subject to some potential compulsion to do so?
I think that there is always that possibility that he would not comply, given our the compliance issues to start off with. I do think, however, he should be evaluated by, for example, circles of cares, forensic multidisciplinary team for competency restoration, and that would give us some additional information as to their observations and take on how much of this is a clear mental disorder versus a motivated attempt to frustrate.
I did have one further question. I said that would be my last, but I do have one more.
All right.
In your competency evaluation, you conveyed an impression that this the delusions or delusion-like beliefs that he has didn't pose a danger to the community. Is that correct?
Yes, sir.
Why is that?
Well, there's no evidence that I had from any of the information that we had any past history of aggressive threat, what we would call threat override symptoms, which with psychotic disorders, threat override symptoms are the ones that are more directly related to concerns about aggressive threats. So basically what that means is that the individual does have a paranoia, a persecutory complex, if you will. The world is against them, misreading people's behaviors, etc., as negative intentions. Okay, so we have a hostile, if you will, worldview, combined with a inability to override or control intrusive thoughts, typically command hallucinations, and which is part of psychosis. And I have had no evidence and observation of him that, or what little I knew of his developmental history, that there was such threat override symptoms and inability to control impulses because of the strength, if you will, of the competing voices and so on.
Thank you. Counsels, either from the state or the defense, whoever would go first, any questions?
So, Dr. Williamson, from what I
This
understand,
is Janet Roberts, the state attorney.
that
Yes.
you are recommending a facility like what was the name of the facility?
Circles of care, the forensic multidisciplinary team, FMT program, who does competency restoration training and provides psychiatric services for individuals who, have been deemed as having a psychiatric disorder, but are incompetent to proceed to trial.
And just to be clear, at this point in time, you are recommending that route. Is that right?
That would be correct, yes.
Okay, that's all.
Ms. Roberts, anything else? Any questions?
Good morning, Dr. Williamson. This is Jordan Roberts with the defense. So I know you weren't able to go through the full evaluation that you typically would do, but just based on your limited interaction with him in the office, reviewing the case file and the different filings, I just kind of wanted to get your impressions on some of the competency standards, like his ability to appreciate the charges before him and kind of how the legal system works, what my role is.
Yes, ma'am. So first, I would say that that's one of the reasons that I am suggesting that I think that there is more of a psychiatric element or component to this. So the if you look at both statements that have been made and his various filings, it seems very clear to me that he does not understand, in essence, the basic roles, respective responsibilities of courtroom personnel. The fact that we have a misdemeanor case, which theoretically could be easily resolved with his cooperation, and he is responding in the manner that he is responding, certainly suggests to me that, again, there is a mental disorder behind all of that. And when Your Honor had asked me questions about the sovereign citizen, I would say that the vast majority of those individuals are using that kind of defense, if you will, if such is a defense, because they're facing serious charges. Those same individuals would be pretty unlikely, I think, to make such a defense on a misdemeanor case. So I do think that there is a reaction here to a misdemeanor case that strongly suggests to me that there is, again, psychiatric factors going on and so on. Secondly, and I may jump here to also our factor about being able, the capacity to consult with counsel. Given his inability, it seems, to recognize what the actual charges are and the distortion by which he has interpreted it, the severity of the charge in his eyes that's against him, and an inability to, basically accept his defense counsel's representation and collaborate. I certainly would say that he's incompetent on the factor of what are the charges that are against him, what is a less or more serious charge, etc., and the understanding the adversarial nature of the legal process and the roles, responsibilities of courtroom personnel. It is clear that he sees the whole process as adversarial against him, but does not make the distinction between the state and the defense counsel, etc. That would then lead to the next one, which is I don't believe he has the capacity to effectively collaborate with counsel. I'm not there or able to pick up on what's going on in the courtroom, but I think we're likely seeing behaviors in the courtroom that would also indicate incapacity to proceed. And if his legal documents are any indication of what he would testify to, if he doesn't choose to not testify, from right to remain silent, all of that also indicates to me that there is a underlying incompetence. So certainly it's possible that there is a deliberate and conscious attempt to frustrate this process. I would say that, however, that the illogical nature of the way in which that's being done, and I do like the Alice in Wonder looking through the looking glass quote. Yes, we have gotten to a place where the language is meaningless because it's just very unclear as to what he is referring to in regards to his own case, the logic of that, and what seems to me in trying to figure it out is almost blatant contradictions in what he is using as his defense.
So I'm
sorry, that was a long-winded answer, but.
Thank you. So just kind of based on having touched on the factors that you would have gotten into in the evaluation, if Judge was to make a finding one way or the other today, do you have kind of an opinion or conclusion for him on whether or not Mr. Farnham may be competent to stand trial in this case?
So recognizing that such a decision is ultimately in the judge's purview, I do feel that he is incompetent to stand trial because of psychiatric factors.
Thank you. That's all I have.
Anything else for Dr. Williamson?
No, Your Honor.
Dr. Williamson, thank you very much. It's rather unusual to have the psychologist or psychiatrist testifying at these hearings because we typically have a competency evaluation that addresses those various different criteria, but I thought it was valuable in this particular case.
Well, I actually appreciate it, Your Honor, because, and if it is at all possible, I would like to have that article or give me that reference again?
Yes, sir.
Your assistant? Yeah.
The article that I was referring to, and as I said, I read it last night. It's called Integrating Non-Psychiatric Models of Delusion-like Beliefs into Forensic Psychiatric Assessment.
All right.
The author is a Joseph M. Pierre, Pierre, and it appears in the Journal of American Academy of Psychiatry and the Law, online, June 2019.
Awesome. And yes, but I was going to say too, it also allowed me to look up some information on treatment of delusions, et cetera, that I found very helpful. So I do appreciate being included in this. And if there is anything that I can do, I certainly am willing to do that for the court and for the benefit of all parties involved, including Mr. Farnham.
Thank you, Dr. Williamson.
Thank you, Your Honor.
We've used up quite a lot of time, Dr. Williamson. At this point, I'd be prepared to release him
Yes.
to go about his practice. Any objections? State,
objection.
defense?
No objection.
Thank you, Doctor. It won't.
Thank you, Your
it
Honor,
won't hurt
very
anyone's
much.
feelings if your cursor makes its way over to the red leave button in the upper right-hand corner there too.
Yes, sir.
Thank you.
All right, thank you.
All right. Let me say this. Before someone would be found incompetent by the court, he has the right to make some presentation, I believe, before the court. So I'm prepared to have that, directing myself to the defense. Is there any such presentation that should be made to the court at this point?
Noting his objection to my representing him, I'm aware that he is objecting, but
Did you want to consult with him on that?
I mean, we spoke earlier. He's made it very clear he is not the party here. The birth certificate and the DNA documents are who we are actually discussing. He is not agreeing to be the surety for these proceedings. I think based on Dr. Williamson and the case law, I don't think we have any further full presentation. The case law makes it pretty clear it ultimately resides with you to make an independent finding of whether or not he is competent or incompetent to proceed, regardless of whether or not the parties have stipulated to the report or competency itself. But I think Dr. Williamson's recommendation, even in his limited ability to review the case, was... Just
on my narrow question, though, and I'm thinking, too, about the record of the matter, is there any other presentation by the defendant or on his behalf that should be put before the court?
I object, I'm not the defendant, I'm accused. I have a question, is that a maritime flag there behind you, Your Honor?
Okay. Anything else, Ms. Roberts?
Can I reflect on the record that Mr. Silverman refused to answer my question about the maritime flag, and that appears to be a maritime flag. Can I ask the clerk, is this a maritime venue in which we're in? Clerk?
Anything else, Ms. Roberts?
No, Your Honor.
All right. Before I talk to the state, inquire of the state, my impression of Dr. Williamson's testimony here under oath went further than his competency evaluation did. He was more qualified in the written evaluation, given the limitations of his assessment of the defendant. And he seemed to offer a more conclusive opinion as to the defendant's incompetence at this point. So I want to hear your position, any presentation that you would have on this matter.
When I've read his report, not the letter, but the report that
Yes.
followed, I felt that was sufficient on the issue of incompetency. Today, he talked about that he did consider malingering as well, but that he ruled it out and still found that if there's malingering, it could be better resolved at the Circle of Care, whatever the name of the facility is, but that it was still his opinion that the defendant was incompetent. And he did go through all of the legal steps that he's required to address, which I believed he did in his report as well, maybe not quite as direct and to the point. And I think the only issue at this point is whether the court finds the defendant competent or incompetent. I don't think it's helpful for a defendant who has already, where Dr. Williamson has found him to be incompetent with the delusions of grandeur. I don't think it would be helpful to have him appear at the podium and have a chance to represent his views to the court. I think the additional outbursts that have occurred today, I'm sure are of record, and that is sufficient in and of itself. And I would just ask that the court go ahead and make a decision. I am not asking for a second opinion, and I am adopting what Dr. Williamson has said, both orally and in writing. I might add that what Dr. Williamson didn't have, there was a flurry of extra documents that my office received, both through Your Honor and directly from the defendant, on still more documents, and all of them in the same vein and same word salad that Dr. Williamson used, without logic and without a clear understanding of the judicial process.
First of all, let me address that same point. I would not put the competency evaluation of Dr. Williamson typically into the public record. We're not filing it in the court file, but in the event that there is some later appellate review, it can be produced. Any objection by considering it in this, for this purpose in terms of competence, determining competence, Jordan Roberts?
No objection. I think his testimony today elaborated on many of the factors that would have come out in an evaluation had there been cooperation.
May I just say one more thing, Your Honor?
Yes, ma'am.
At the last hearing, where we were, the defendant had taken the fifth and left Dr. Williamson's office. Your Honor had made it clear in the hearing that if he didn't, he could be taken into custody until he appeared for the evaluation. And then all of a sudden, the defendant himself made another appointment and did go for the evaluation.
No, I'm not sure that that's the chronology. I was under the impression that he appeared for an appointment arranged by his counsel. Is that not correct, Jordan Roberts?
There had been an order out there to comply with the evaluation that wasn't originally complied with, so he had a mandatory court appearance where he was informed he will either appear for the evaluation or potentially face contempt of court charges. He then appeared for the evaluation, explained he was invoking his Fifth Amendment rights, which is outlined in the evaluation by Dr. Williamson.
So my point was, if Your Honor would order restoration.
Your position is that he'd understand that?
If he understands
Well,
that he could be held in contempt if he does not.
We can cross that bridge when we come to it, if we come to it. That's secondary to the threshold determination of competence. I'll tell you what I'm struggling around with. It was the same question that I asked Dr. Williamson. you have someone who the effect of what they may be doing would be to frustrate law enforcement and obstruct the judicial process.
I object to that.
There is I called it to Dr. Williamson a movement of such persons doing that. And we are perhaps more tolerant as a result of the internet and other cultural acceptance of fringe beliefs, conspiracy theories, other. And I am reluctant to identify in some blanket fashion all of the people in that movement who so respond as incompetent, which in a manner which would then tend to immunize is not the correct word, but it creates a presumption that, or at least an inference, that in the future they would not be competent to proceed in some subsequent case. I don't feel I would, now let me say this. Dr. Williamson directly addressed that contention, which I illustrated with the quote from Through the Looking Glass. Should I be concerned? That's my question to counsel about that
See, what
proposition.
I believe that he did address it, and he did make a distinction between all of the other people he had evaluated that had the same sovereign citizen claim. But he also,
I object. I do not claim to
but
be a sovereign
also-
citizen. I object
but
to
also,
that.
Your
I
Honor-
do not claim to be a sovereign citizen. I object.
okay. But also, Your Honor, by going to the circle of care, they're going to have more forensic and evaluations that are open to them. And if that be the case, then he will quickly be coming back out. And or if they believe that he has a true delusion and can
That's-
participate in restoration, we'll know from further reports.
Should I be concerned, Jordan Roberts?
I think, and I know Dr. Williamson kind of touched on, he doesn't apply kind of what they're doing to the actual facts of the case from a legal standpoint. He's aware of the movement and how this is clearly distinct from some of the filings that may happen in those cases. I think I could clarify. I do think that he's right, that this is very distinct from some of the other people who are in fact claiming to be sovereign citizens. Just having reviewed different potential defenses that have been sent to me regarding, a lot of times it's driving while license suspended cases, there's a logical connection from driving, I have a constitutional right to travel. It may not be an appropriate legal defense. It may not be case law that's actually binding or persuasive. It may be something that talks about driving, but it's some IRS tax code that they found. But it has some nexus to, they can't tell me I wasn't free to driving because this talks about driving or a vehicle. There's a nexus to what's going on with them, even if it does not apply. Here, I think many of the filings have made it very clear there is no nexus to the ultimate charge of resisting, and whether or not none of this is a defense to the allegations that were outlined in the arrest report. We received a filing this week that the presumption of death has been removed. I think it's very clear there's a distinction between the filings in this case and how they may appear sort of in the sovereign citizen vein, but I just don't think that's the route that was taken here.
The videos that are in this case and multiple officers on scene support a far worse behavior than what you've seen in court or even through the documents. The videos were horrible as to how he acted. And I'm not saying that he's not malingering. You know, it could be maybe Circle of Care can do a malingering evaluation as well as their restoration treatment.
So you don't believe from your evaluation that he's feigning this?
Myself personally, Your Honor, I do believe that he's malingering.
You do?
However, I do. But I'm not the doctor that examined him, and I'm not a doctor. And the doctor considered that, and he considered the delusions, and in his professional opinion, he believes that he needs to go to the Circle of Care. And I believe that because of that, I don't think any conviction would withstand an appeal if he's not afforded that opportunity.
Okay. Let me put it in a fashion that's designed not to intrude upon any attorney-client privilege. Would it be accurate to say that there's nothing about your interactions with him or your observations of his behavior that would detract from the validity of the opinions offered by Dr. Williamson?
Based on conversations and stuff that's not available to Dr. Williamson or the court because they are privileged communications, I would not personally hold the belief that there is a false representation in an attempt to just paper the state to death into dropping it. I think that firmly believes in the motions that are being filed. I don't think it's an attempt to get out of anything. Obviously, Dr. Williamson has reviewed many of them. I think knowing, based on further conversations I've been able to have, I don't think this is a mere attempt to get out of the case. I think this is just genuinely.
I want to thank both counsel for their advocacy in this matter, and I'll draw an order. At this point, I'd like to go ahead and continue the competency continue the matter for docket sounding incompetence to 8 a.m. on March 14th. Direct the defendant to appear in person for that proceeding. Please put that in the minutes. It's a mandatory appearance, and that is justified by the factors that I put forth in the prior orders, including but not limited to the defendant writing the word rejected across a notice to appear that he had been furnished, and then directing that back to the court. We'll have an answer by that point. I won't have an answer, I expect, by the close of business today. I want to think it over. Furnish that paperwork to the defendant. Take it under advisement. I'll do the order. That's it for now. Now, let's go back to the list. I know we're running late, but it was unusual to have such testimony during the course of the docket sounding.